Questions? Anybody have a question or comment or? Yes, real loud.
If you're a privately held company,
Yes.
you have public financing. How should, I've run into this, where they'll say, oh, now we're privately held, and now we still got to keep these records because we have public financing, so therefore we have to follow Sarbanes-Oxley.
If you're privately held, what's with some public financing, like bonds or things like that, do you still have to follow the provisions of Sarbanes-Oxley? Number one, a privately held corporation does not have to follow Sarbanes-Oxley. Would you want to do the quality assurance types of things? It's probably a really good idea. I have seen a lot of privately held companies make decisions to establish, actually I saw one that got certified by ISO 9000, even though it's a manufacturing quality assurance standard, because they wanted to show they have good processes in their organization. And then if you want people to feel good, when you float a public bond in the public, that when you provide financial information, it is accurate and they can rely on it and they can trust you, I think it's a good idea, but I don't think you have to. I think it's a good idea, but it's not a requirement. Okay? I'll take one more and then I'll go on to the next one. Yes?
I don't mean to sound dumb, but I'm part of a law firm that deals mainly in litigation and estate plan matters. How does Sarbanes-Oxley relate to us?
Probably does not. You're privately held. And therefore, you do not have to follow Sarbanes-Oxley, but you're going to advise your clients about that a whole lot. And it's important for the law firm to fully understand it. But again, I'll go back to the previous comment. Quality assurance for financial records is a real good idea.
No, but my county firm is pretty
Yeah, but to do it very formally is better. Right? Okay, good. All right, let's go on, and if I don't get your question in, I'll be glad to take them after, and I'll be around during the conference. Okay, and as I said, most misunderstand the basics of Sarbanes-Oxley. This is a fun one. Who is this? She's one of the only non-politicians like Sarbanes and Oxley who has a law named after her. Lilly Ledbetter. And the law has created controversy. After Lilly Ledbetter came out, I had no idea the law came out. I had gotten a number of requests. And then I had to start researching, and I found one article after another by attorneys saying you now have to keep all your payroll records forever. That was the response, and by the way, we still hear it. Okay, so Lilly Ledbetter Act came out in 2009. What happened with poor old Lilly? She was employed by Goodyear Tire and Rubber. They apparently weren't paying her enough. They were discriminating against her, as the Supreme Court in 2007 determined that there was pay discrimination going back several years. The Civil Rights Act allows 180-day statute of limitation to resolve discrimination or to begin a lawsuit for a discrimination suit. But they discovered, which is correct, that going back 180 days would not resolve the problem of this pay discrimination that had been going on for years. It would resolve it from 180 days ago up to the present, but not the historical discrimination. So the Ledbetter Act says each paycheck for which there was discrimination can be reviewed. So if there was discrimination 20 years ago, that paycheck can be reviewed. The plaintiffs could go back an unlimited number of years. So let's say in 2014, somebody brings a pay discrimination lawsuit. They can go back to the beginning when the person was first hired, subpoena all the records, examine what this person was paid versus other people comparably situated, and determine what that person should have been paid up to 180 days ago. Okay? So they can show what the pay should have been, because if they were discriminated, the pay is way lower in 2014 than it should have been. If they had received the right amount, the pay for 2014 would have been at a higher level, and now we can deal with that question. But the law does not say that you can collect the accumulated loss in the paychecks. All that can be done is you can go back 20 years, 15 years, 10 years, figure out what the pay should have been, determine what the salary should have been as of 180 days ago, whenever the lawsuit was brought, minus 180 days, and then claim recovery for discrimination at that point. Okay, so the accumulation of discriminated pay cannot be collected. Lilly Ledbetter does not provide for that. In fact, it says that the Civil Rights Act of the 180-day statute of limitation is still in effect. It establishes a right for the plaintiff, of course, to search back any records that may exist, determine whether there was discrimination in pay. The company has no requirement. There is nothing in Lilly Ledbetter that requires you to do anything different than you have done historically. You don't have to keep more records. It doesn't say. But if you have them, the plaintiff can go back and figure out what the salary should have been in 2014 as opposed to what it really was, and then the claim is made as of 2014. There are numerous laws establishing retention requirements for payroll. Don't worry, we have plenty of them. If you don't know how long to keep payroll records, I can give you probably 50 of them. They don't all say the same thing, but every state has requirements. Federal government has requirements. What's the impact of retention on payroll records? Many attorneys claim the companies now must keep their payroll records forever or indefinite. Why? Because they saw the provision. You can go back and research the historical records. So they all of a sudden thought you had to keep them. Supreme Court never said that, and the Lilly Ledbetter Act never said that. It's not required in the law. It would be a huge retention and discovery burden. Can you imagine? Well, many of you keep your payroll records forever anyway, so you don't have to imagine. You live the nightmare. You don't have to keep your payroll records forever. That never was a requirement. And if you do so, you pay the price for doing so. We have recommended for the longest time 6 years. By the way, we changed our normal recommendation last year. It used to be 8. Anybody from the great state of Minnesota? Bless your little hearts. Minnesota, several years ago, came up with the only 8-year requirement for payroll records in the United States. And they recently changed it to something reasonable like 4. And there are some that are a little bit longer that drives us to 6. So 6 years for payroll records. I can show you the research if you need. Okay, that's the end of that one. Okay, Lilly Ledbetter, it is not what you think it is. Your HR people are probably going berserk over this. Go and Google it also. read some of those ridiculous articles written by attorneys who all of a sudden say you got to keep the records forever. If you have no law requiring you to keep the records forever, and you have many laws that say you don't have to keep it longer than 6 years, is it reasonable to keep the records for 6 years? Even though the plaintiffs would have liked you to keep it forever so they could search and find the discrimination. And by the way, when we talk about discrimination in salary, they don't look at one person. You can't tell discrimination by the salary of one person. You have to look at many other employees, comparably situated, and see how this one person, what their situation was, and did they fare properly compared to the others. That meant whole department, whole company of records would have to be kept if you think that's what the law is telling you to do. All your payroll records. I don't believe that's what the law says. That's not what it was intended to do, and it was quite specific that there is no recovery for the historical discrimination. Okay. Question on Lilly? Yes.
On the 180 days, is that a 7-day week, or is it based upon a work week for an individual?
You stumped me. I don't know if the 180 days is working days or calendar days. I have absolutely no idea. If you write me after the session, I will give you the answer, but I'm pretty confident it's calendar days. Because statutes of limitation are written that do not discriminate, on weekends and stuff like that. They talk about 6 years, and they don't say, but if it's a leap year, you get 6 years and 1 day or anything like that. It's a question back there. Yes. Real loud.
Is your recommendation of 6 years based on a trigger of payroll date of 6 years or employee termination?
The 6 years, the question was, is my 6 years based upon a payroll or termination? If I was talking about termination, I would have written it active plus 6. The active period being while the employee is employed plus 6. No, I mean absolute 6 from the time of the payroll, because that is, if you look at how the laws are lined up, they don't require payroll records to be kept for the life of the employee. We're going to get into the more interesting one, which is ERISA, in a second. And this is much more controversial, but it deals with the same type of issue. Okay, let me move on so we can cover at least the core material that I wanted to in today's session. Okay, ERISA, here's the whole name, Employee Retirement Income Security Act. Okay, so here's the one. Does anybody know what a Studebaker is? Oh, okay, you're giving yourselves away. So in 1963, I just thought a little background on these would be of interest. Otherwise, my presentation would be boring and miserable. Studebaker Corporation closed a plant. I don't even remember where it was. The pension plan was inadequately funded or illegally misused. There's a lot of money missing in the pension plan. Very common story. This has happened in a lot of situations where companies have closed. Happened with the automobile companies. They were underfunded. There was money missing. They couldn't always explain where it went. But there certainly wasn't enough to pay all their obligations. Only some employees got benefits to which they were entitled, and others, of course, got little or nothing. Most got nothing. And Congress was brought in to do something about this situation. So all these laws come from something. Congress doesn't just sit there and make up, well, I guess they do sometimes, but most of the time, there's a reason for it. Let me give you one of the more interesting things. It had nothing to do with my presentation. Do you know that there are records retention laws on matches? Because somebody got burnt by a match, or injured. And there are no records retention, where you have to keep the records provisions for butane lighters. There are records retention requirements for lawnmowers, but nothing for hedge trimmers. Just as dangerous. It's just because nobody had a problem with a hedge trimmer or a butane lighter. And that's how we got a lot of laws. It's just there was a problem. Congress went to resolve that problem, and sometimes nothing else, just that limited area. Okay. ERISA came out in 1974. Well, what's this big gap here? The 1963, the company went bankrupt, and ERISA came out in 74. They came up with all sorts of provisions during that period. Nothing, they weren't happy about it. They couldn't pass anything, etc. Finally, in 1974, they came to an agreement. Employers are not required to have employee benefit plans. They made this clear. We're not telling you as an employer you have to have health insurance, a pension plan. You don't have to do any of that. But why would an employer do these things? To entice employees. And it became very competitive after a while that companies that offered better benefit plans were likely to be able to have the pick of employees. Those that didn't offer benefit plans, the employees didn't want to work there. So that's how benefit plans got into the business arena. And I won't say the next part. Why healthcare insurance got in the business world and not in government. Primarily covers pension plans. That was the main goal, but health plans, health insurance plans are also covered within ERISA. In terms of the pension plan, the couple requirements, many of you are already familiar with it. Employees vest in 5 years, must be adequately funded, and there's reports to employees in the government that are required. Okay, let me ask you a question. Most of you are working for companies. Do you get a report on the status of your pension plan each year? Raise your hand. Okay. Is there anybody in the audience who does not? Okay. Important point, and we'll get to this. Okay. Then there was a creation of the Pension Benefit Guarantee Corporation. I'm sorry to throw all this at you, but it's important to understand the whole context because they have a very important regulation. They say that if the coverage of the plan is not sufficient, the assets aren't sufficient to pay the obligations under the plan, the Pension Benefit Guarantee Corporation will pay. That's the goal. But in order to make sure they're not paying while the presidents of corporation are stealing from the pension plan, they require the company to keep records to show the plan's sufficiency, that the plan is being implemented and there's money. And I guess I didn't include this slide here, but you also have to keep those records for 6 years. I think I repeat it in just a second. So there's an absolute requirement for contributions to a benefit plan. So if you pay, the corporation pays, say, either 401k or any other type of plan, how much was paid in, the reports that are given to employees, they have an absolute 6-year requirement. And I think it's in another slide too. As I said, ERISA also covers some health insurance. Most of you know HIPAA for another reason, the Health Insurance Portability and Accountability Act of 1996. But the plan is also covered by ERISA because it's a benefit plan, so the plan must cover pre-existing medical conditions. Plan may not discriminate. And I'll throw the last set of abbreviations at you, COBRA. I decided not to write it out because the meaning of COBRA has nothing to do with what the law is supposed to do. So just think of it as COBRA. If you leave your company, you have a right to continue paying for your health insurance and keep it in effect for a period of time, and that's what basically it does. The employees and beneficiaries continue the coverage after termination. There are two types of pension plans in the world, and it's important to understand the differences. One's real easy to deal with, the other is real difficult to deal with. The defined benefit plan is the difficult one. This is the old style pension plan. You work for the company for 40 years, you're at this level, you will get X number of dollars for the rest of your life. Doesn't matter if you paid in a penny or not, it's whatever the rules of the game are. This is the old style, okay? So we don't know what the person will be paid until they terminate. Depends on years of service, it depends on salary, it depends on level that they've been promoted to, things like that. The new type of pension plan, which is like the 401k, is the defined contribution plan. Instead of talking about what the benefits will be at the back end, we'll talk about what you pay in. So the company says, we'll pay 2% of your salary into the 401k, and an employee can match it up to 2% with their own money if they want to, or something, or they don't have to. Okay? So money is paid into the account. You generally have control to say how it's to be invested. And at the end of the year, when you get your statement, which everybody said they had statements, basically it says, here's the value of my account with the amount of money that's been contributed, with the directions I've given for investment. Here's how it did. I have $100,000 in my account. If you were with the company 5 years, most have 5 years vesting before you get the rights to all the money. If you terminate, you take $100,000, and that's your pension plan. You can convert it to, monthly payments, etc., but it's what's in the account is what you get. Defined benefit plan is what you were promised is what you get. Totally different world. Some advocate keep the pension records forever to confirm the contributions, the benefits, investments, and in those discussions, most of those people fail to distinguish between the two types of plans.